Okay, now I'm going to try to demonstrate a very, very short version of a confidentiality class. And understand that if I were covering the topic of confidentiality completely, it would be probably 2 or 3 90-minute classes. So we will do what I can do so that I can demonstrate the methods a little bit. I did want to clear up before we started back again that there are terminology differences all over the world, right? So when I say lawyer, I actually mean all of the legal professionals. I mean private attorneys, I mean judges, I mean prosecutors and other government lawyers, I mean company lawyers. We don't have notaries like continental European systems have, so I don't mean, I would include them, but nonetheless we don't have them. So I understand that my term might not match up perfectly, but I'm trying to talk about all at the same time, even though it's impossible to talk about all at the same time. And it's impossible to talk about all at the same time for the reason I gave an hour ago, which is that part of this subject, the law that governs these different legal professionals, if you will, is about their role in the system of justice and where they fit. So judges have obligations that private lawyers, private attorneys don't, and vice versa. And in terms of confidentiality and things like that, what is expected of a government lawyer or a company lawyer is different in some ways from what is expected from a private advocate. So when I say the word lawyer, I mean the whole legal profession, but with the understanding that you have that these topics are going to apply to them in somewhat different ways all across the board. So does that help? Okay, all right, great. So shortened version of confidentiality class, that's what we're going to try to do. Forget being a lawyer for a minute. Forget that. Just as a person, how many of you have had someone come to you in your life and say something like, I need to talk with somebody about something very important. Can I speak with you?
Sure, no problem.
Sure, of course, right? How many of you have had that happen in your life? Everybody, of course. You are all trusted people, right? How does it make you feel as the recipient of that message? What happens to you?
Proud.
Proud. You're
scared.
A little bit scared, right? Why are you scared?
Because it means that the person is going to say me probably something important, and you need to be careful with an important message.
Okay, it's a responsibility, in other words. You feel a level of responsibility about it, but you also feel proud and trusted, don't you? Right? So it makes you feel good. Does it make anybody feel angry? No?
Strongly depends on who's asking.
Depends on who's asking. Okay. So yeah, I've had sometimes students, and I'm going to treat you like students, though I understand you are not. Right? I mean, I get that, but yeah, sometimes I've had students some places tell me it makes me angry when somebody says that. It's kind of putting an obligation on me. I don't want it. So I'm not happy about this at all. But that's the minority, right? Most people feel kind of proud. Most people feel trusted and special. Before you even know what it is that they want to tell you, does it already start to put some sort of moral pressure on you to keep their secret? Yeah, it does, doesn't it? So, will you keep their secret no matter what they tell you? Can you imagine anything someone might tell you? Even after you've said, sure, you can talk with me. You can talk. That's what you said to me right away.
Yeah, of course.
Of course, right? You feel good. You feel trusted. You feel proud. So you're going to say, yes, I'll do it. But can you imagine things that I could have said to you that you might say, I'm not keeping that secret?
I wasn't a lawyer. Well,
You're not a lawyer.
I can think of such
situation.
You can think of such things, yeah?
I think that there can be situation if he say me something about something wrong about my family or against my family, I should privilege my family against
Over
him.
this person?
Yeah, over this
Yeah,
person.
okay. Anything else? Can you think of other things?
There can be even, it can be even in the interest of the person sometimes. For example, it can be like medical information
About?
his conscience, and like then I would have to make a decision.
Yeah, so-
Is that,
Okay, so in all these situations, and I'm sure we could think of more of them if we, had 4 90-minute sessions to spend, but in all of these situations, what are you doing? You are balancing this moral pressure to keep the secret that is created by the act of confiding in you. That's all it's created by this person placing trust in you. You're balancing it against the harm that might come to your family, to some person because of a medical issue, to a danger, to whatever. You're balancing it against the harm that might come, okay? Now, when you get to be a lawyer, what happens?
You have the duty to keep secret if it's, but it depends.
Yeah, and you don't even know this person who comes to see you as a lawyer all the time, right? In life, the situation we were talking about, almost surely this is a person that you are friends with. This is someone that trusts you, that knows you, that you have a relationship with, right? Somehow, by being a lawyer, now private lawyer we're talking about, and posting this document on the wall, right, that says you are a lawyer, you are licensed to do this work by the state, somehow, it makes you someone who is a sort of institutionally trustworthy person. Just by belonging to this club, if you will, right, this profession, you become someone that this client does not need to have a prior relationship with in order to be assured that you will be trusted with their secrets. Nonetheless, do you think it's the same? Are there going to be occasions as a lawyer, private lawyer, avocat, that you would have to stop and say, oh no, I'm going to have to reveal this? Or never?
there are occasions.
There are occasions, right? But these, are they balanced person by person? The way you balanced your family's interests, you balanced somebody's medical concerns, we balanced some threat to another person. We did that all individually because of whoever we are. And you might balance it someplace different than you would, than I would. But how is the balance made as a lawyer? How is the balance made as a lawyer?
So we must obey the rule, some ethics code of lawyers or something like that.
It's balanced institutionally, right? Because you got this power because you belong to this profession, not because you are trusted by this person, you have a relationship. And I think everybody in the room would agree that the relationship you have with the person who confides in you, if you're not a lawyer, we're just talking about life now, that will weigh into how serious the bad thing is that you will finally decide to reveal, right? Maybe it is a family member who comes to you and talks to you. Maybe it is the friend of your whole life, right? It will matter how you will balance those things out. Here, your profession and the law has already made the balance for you, or tried to. Now, like all other rules, these rules are going to be imperfect. They are not going to cover every situation. Even though, and maybe you'll say this is true for you too, in my experience, many civil law lawyers believe that everything is somehow covered perfectly by the code. Do you believe it? No. But some civil law lawyers do, and judges as well, right? They think everything is bound. There's no need to interpret. It is what it is. It's all there somewhere. If you could only find the right article, right? It is like magic or something. I think that's not the case any more than it is for a common law lawyer to think that our rules are perfect, because ours are never perfect. Anyway, we are talking about, in life and the profession, exceptions to a duty of confidentiality. Exceptions to a duty of confidentiality. Okay. And we'll talk for a few minutes about these, but not very long because of limitations of time. Now, there are usually two separate sources of the lawyer's confidential relationship with a client, usually two separate sources. One of them will be a law on advocates, or for us, the code of conduct that we have for lawyers, and as well in many countries, there will be a code of conduct that functions underneath the law on advocates. If the law on advocates has given power to a bar association to create such a code, it will also govern the lawyers underneath it. At least I picture it underneath. Is that how do you imagine the relationship between the law on advocates, and if it authorizes a bar association to establish a code of ethics or code of conduct, do you sort of think of the code of conduct as being underneath? No, you don't think of it that way. How do you think of the relationship between the two? Is it subordinate to the law on advocates? What if something in the code of conduct that the bar association adopts is contrary to the law on advocates? Which one would prevail?
Well, of course, the law.
Of course, the law, right? So I think of it as operating underneath, like it's subordinate to the law on advocates. You're all looking at me funny, so you think of it differently.
I was just wondering that the code of conduct is not a legal norm, because it's not general.
Yeah, so I think of it as sort of a sub-legal norm, right? It's not a law.
It's an internal norm with a different kind of
It is.
obligatory character.
And yet, if it is some power delegated by the parliament, it is in a way like an agency. In a way, it's like a state administrative agency that creates it.
I'm not sure. I think that the code for barristers in the Czech Republic is just for the bar and for the members of the bar.
Okay.
On the other hand, the law for lawyers, all the laws for
Yeah.
different kinds of legal professionals are binding, legal binding. So
Okay.
there is a different type of binding force.
Yeah. And it is a different kind of binding force. I think we just have different ways of thinking about it in our heads, or different terminology to use for it. Because the Bar Association can punish you, right?
Yeah, of course.
Of course. And they get the authority to punish you from the law on advocates.
Yeah.
Yeah, so in my brain it works sort of like an administrative agency that does something. But I see how it is different. I see how it's different also. Okay, so so the profession itself, or the law on advocates, depending on how detailed it is. In some countries it's very detailed. In other countries it's very, very general, and it relies on this code of conduct for private lawyers underneath it. It will establish these balances for you, okay? All right, so two sources, we said two sources. One is a law on advocates or a code of ethics that tells lawyers they are to be confidential with their clients. Where's the second source? What else am I thinking of that exists in the law? I know it exists in Czech law. That is a sort of legal protection for the information that passes between lawyer and client. It creates a confidential relationship between them in a way.
Contract between a client and a lawyer.
There's a contract for sure, but there's something else. I've seen it, I know you have.
There is exception saying that you don't have to report the crime.
Don't have to report a crime. And there's also a provision that essentially exempts a lawyer from having to witness against a client, right? And that, in a way, is a form of protection of the confidentiality. We call it an attorney-client evidence privilege. That's our term for it. But in most countries, it functions as a provision of the Criminal Procedure Code or the Civil Procedure Code that exempts lawyers from being obliged to witness against their clients in some way or other. You have something like that, I'm sure you do. Yeah. So there are these two sources of this confidential relationship, right? Why should it be so? Why shouldn't lawyers have to tell? Wouldn't we get more information about crimes if lawyers had to tell? Why not?
I believe that not because the clients would know and they would not share those information with their lawyers. So.
And then what would happen to the system of justice, to the way in which we administer law?
They couldn't get the fair trial because there would be no one to protect them.
Okay, and what else would happen? What else would happen? There really, usually we think of two functional reasons why we want law-trained people. They can be company lawyers, they can be, although company lawyers in Europe are treated quite differently than they are in the US, quite differently. You know, the Axo Nobel
I think that there is
case.
a general argument on this because the main, how can I say, the main work of an attorney or barrister is to serve his client in the best way in his interest, and in his interest is not to report the crimes or his outlaw behavior.
Okay, okay. What else would not happen? Let's think of it in terms not of a criminal matter so much as a business. When they ask a question of a lawyer, what do they often want to know? What does a business want to know when they come to a lawyer? Quite often, whether it's their internal lawyers, their company lawyers, or they go to a law firm, they go to Kinsteller and they want to ask Kinsteller lawyers a question.
So they know some know-how of this client?
They have know-how about them, right?
So they work for the other side, for other companies?
Well, if they work for other companies, they maybe cannot. That'll be a conflict of interest problem we'll talk about. But they often come to the lawyer to say, are we permitted to do this? Is this a contract that is going to be respected by the courts and the law? Is this a transaction? Is it a business arrangement that is a proper one or an improper one, and therefore will produce trouble, let's say, with the competition laws or with other constraints on businesses? So we think that if there were no confidential protection, between lawyer and client, and I mean all sorts of legal professionals, again, two things would happen. One is people would not get proper representation because they would have no one they could confide in. And number two, lawyers would lose the capacity, law professionals would lose the capacity to counsel their clients about the way to behave in the future, about the proper way to behave in the future, right? I mean, there are all sorts of laws that businesses need to comply with, aren't there? And they have their internal company lawyers, but they also rely on law firm lawyers to get advice about complying with those laws. And they need to be able to be candid with those lawyers if they are going to get good advice. They need to be able to do this. All right, so we think there are reasons why we should have this confidential kind of protection. Now, the next thing I would do, and we're going to do it in a very, very, very brisk fashion, I would actually walk through what exists as written exceptions in the US law at least. And if I were teaching the course in Czech Republic, I would compare it to the, to the Czech law on lawyers and the Czech Code of Ethics and see how they matched up. But I would walk through them very quickly, but I would go back and forth with the students, something we don't have enough time to completely do. But you'll see that there are exceptions to the duty of confidentiality to prevent future physical harm. Okay, the first one is prevent future physical harm. The second and third, actually both are relatively new provisions in US law. They came into being after, do you know Enron? Have you ever heard of the Enron? It's a big corporate financial fraud case that took place in about 2001, I think. And shortly after that, we got new exceptions to the duty of confidentiality, allowing lawyers to reveal certain things that they didn't used to be allowed to reveal. So second and third they're kind of time different from each other, but they have a very important provision. These are both about financial interests or property, preventing harm or rectifying harm to financial interest or property, but only when in furtherance of which act the client has used the lawyer's services. So if I'm a lawyer and I learn about my client's financial frauds, but the client hasn't used my services in any way to help those frauds, these exceptions do not apply. And I am left not able to ethically, we would say ethically, reveal it in compliance with my lawyer code. The fourth one, we don't need to talk about it. The fifth one is sometimes thought to be a controversial one because it is essentially an exception that is meant to serve lawyers. So if my client accuses me of some kind of wrongdoing, I will be allowed to use my client's secret information to protect myself. And, this is where it gets used even more, if I'm trying to collect my fee from the client, I am allowed to use his confidential information to collect my fee, which is obviously a self-serving professional exception to the duty of confidentiality. And the final one is to comply with other law or a court order. Okay, and what that essentially allows is two things. One, when you are a lawyer and you maybe represent a business that has to file periodic reports with government overseers, agencies. So if I represent a bank, I represent Raiffeisen, for example. They have to make reports about their financial situation and certain things that are happening inside the bank every so many months to government regulators in Europe. And if I am their lawyer, this permits me to reveal their information because it's required by law for my client to reveal that information. Does that make sense? Okay, same thing with companies that are traded publicly, so securities on stock markets, things like that. They have to comply with securities laws and report on their activities in a variety of ways. If we didn't have this exception, a lawyer who facilitated those reports would be behaving unethically. He could be punished, or she could be punished by the Bar Association for doing what law already requires him to do. So we have an exception for that. We also have an exception for a court order. The typical situation where this exception comes up involves a claim by a lawyer under that criminal procedure code or civil code. In the United States, it's part of our common law system and our rules of evidence that says a lawyer does not have to be a witness against a client. Okay? So what will happen typically is a court will issue papers that say, come in, lawyer, and give evidence against your client. The lawyer will say, no, I will not. I'm not allowed to do that. The judge then refused the legality of the claim that the lawyer's evidence fits within this privilege if you will, that's in the law. And if the judge rejects that claim, the judge will issue a court order saying, I understand your claim that it's privileged. You're wrong. The privilege doesn't apply to this information for this set of reasons. You must speak. This provision gives the lawyer the permission to speak and not act unethically. Does anybody know those provisions in Czech law well enough to know when it wouldn't apply? Anybody know them well enough?
I try to find.
No. Don't. You don't have to find it.
No, I found it before.
Oh.
So it's in the Act of Advocacy.
It's in the Advocates Act. Okay.
But it's very general. Let's say we don't have these six conditions.
Right.
We have in criminal law the attorney advocate is obliged to announce some very serious, not may reveal, but has to reveal,
Must reveal,
to prevent for murder or some other charges.
Okay.
And at the same time, it's not obliged to announce some smaller crime.
Got it. Got it.
So
okay.
It's
so there is some exception built in, but it's not as detailed.
I thought it's more detailed in the ethics code, but it's not.
It's not. Okay.
There's nothing about it.
Okay. Got it. So I'll just give you the example that's most often used in U.S. law. I don't know how it would happen in Czech Republic. If a client doesn't behave as if they want confidentiality, then they get none. So the most common example is if a client comes to talk with a lawyer and brings 3 friends that they're perfectly willing to reveal all of this information in front of, then the protections do not apply. Either the law protections that a lawyer can say, I'm not allowed to come and talk, nor do the obligations of confidentiality oblige the lawyer to keep silent if the client does not behave as if they seek privacy. Or, for example, if a client talks with a lawyer about what would otherwise be very secret matters in the middle of a party with dozens of other people around, easily overhearing the conversation that is too loud for the circumstances, the judge would actually reject a lawyer's claim when the lawyer says, I'm not allowed to come and talk about that. The judge would say, yes, you are. Your client talked about it in front of all, 50 of his best friends. Or he put it up on Facebook. He didn't just tell you, he put it up on his Facebook page. So you're allowed to come and testify about it. Right? So there are times when the law does not protect, such as these examples. When that happens, this exception that says court order permits the lawyer to do it and be in compliance with the ethics code, with the Bar Association code, as well as the law. Okay, now, I would do many other things, and we would study a lot of details about this, but then I would do this, okay? I'm going to ask each of you to be either a lawyer or a client. When do you have to leave?
2 minutes.
In 2 minutes. Then you shouldn't do it.
Thanks for now. I will be back.
Okay, very good. Okay. Each of you is either a lawyer or a client, and I've made you into pairs here, and here, and here, and here, and here. Okay? So in each of those pairs, the lawyer should spend, it should only take you 5 minutes, maybe 10 at the most, to interview your client and learn their story. So the clients need to look at your story and be interviewed by your lawyer, and your lawyer has a list of sometimes difficult decisions to make about what they will do in your case. Okay? So clients, read your fact patterns for a minute, then start a conversation with your lawyers. If any clients have a question about something in your story, you can come and ask me. Don't just let him read your story. Don't make it that easy. Tell him your story.
Já to hlavně vnímám jako věc karmy. Buddhistický koncept je člověk potrestaný za své předcházející činy. Já jsem teď něco spáchal, já jsem někoho zabil, nicméně řekněme, že před lety se něco stalo. Dá se říct, že to byl trestný čin, nicméně dá se říct, že to byla i vražda. Nicméně trestaný jsem to zažil, byl jsem a teď se řeší, jako úplně třeba se podmíněný zavraždil se takže já to beru s takovým buddhistickým
ale já si myslím,
z toho nového ten starý případ nebyl. Starý případ se řešil, o tom nikdo neví. Proč mi nepovídat? No, tak říkám, jak se zajímá o to změnit, tak jsme se připadá jako takový asi jako advokát, který znám nějaké a bylo by dobré, abyste před 3 lety. No, jako v zásadě to byla velmi podobná věc, ale teď jsem v tom jako opravdu proto turecky vidíte, kdyby to nebyl upřímný, jako takový situace, takže na tom vidíte, že teď říkám, že s tím nemám nevidí, tak si to
a jak říkáš, že jsem jako malice
tak kterým se nachází v americkém právním řádu. Právní předpisy. Dejme tomu, že bychom se nacházeli v tom americkém právním řádu.
filtrem, který víme, že byla ta právě samozřejmě vším víceméně má i ten klient a ten klient víme, že vyznačil zkrátka a obecně advokát nemá povinnost a obecně má povinnost předestřít důkazy, že oni ví, že jsme proti klienta. On tam nejde o povinnosti programu činnosti řízení. Takže já to myslím, že on by to sám pro sebe. A případně, pokud si myslí, že to narušuje důvěrnou, že není schopnost řádně vstupovat, protože třeba nějaká strana důvěrný, pak to důvodně, a ten to bylo vážný. To je na hraně, protože každý má právo na hraně.
Tak jako je to
tak to musí, no nemusíš, no, protože ztráta důvěry nebo že prostě...
v podstatě totožná věc,
jasně, ale když to máš nějaký tak si ty otázky, to důvodně nebo to ztráta důvěry, ale prostě nemusíš, můžeme si podmínit nějaká podezřelá,
za to stejné, ale ten
pravda, že já tak to neřeknu nikomu a prostě asi bych to možná zastupoval dál, anebo bych pokusil podmínit dál, neříkám, že úspěšně jak každým státu, ale asi bych říká, že to má všechno logicky. Prostě bych dál co připojím platinu neříkat, nebo nevím, co to může být pro ně
zavazuje práv, zavazuje zákon.
Dám do
tak jiný jako to ne, že samozřejmě co bylo moc samozřejmě na hraně zároveň zákon,
a co ten první trestný?
Co první trestný čin byl zřejmě zavázán,
Já vám dal i čas, to nemusíte odpovídat, ne?
Jasně.
Jako rozmyslet, co se všechno za ty peníze dá koupit. To se jako člověku rozleží v hlavě a ty peníze a škrty se taky jako rozleží. Prostě pak funguje
jakže to nebo povinnost ale že to nebudu podělat i na ten méně závažný
na tu
ale nedopovědět, aby to bylo jako kdyby si sám nesměla
to bylo narušení důvěry, bych na základě toho zákona tak těžko byste mohli
tak když někdo nezjistí, tak jo, tak pojďte na člověk má nějaký podobný způsob, že to by to zásadně taky podpadne. Ale když někdo mohl byste šokovat, že byste jim tam
Have you finished your consultation? Or are you still working with your client a little bit? You're finished. You're finished? Okay, so the chatting was just conversations about lunch or television show. No, you were still working. You were still working. You were still working?
No, we are finished.
You're finished. You're finished? Pretty much. Okay. So if you needed more time in ordinary circumstances, I would give you more time. Of course I would. But I want to move on to do kind of what I would do with this now. So where in the room are lawyer A, client A? Okay, and lawyer B, client B. And you guys are the only lawyer C, client C, okay? Now, if I had a bigger class, I might have 6 lawyer A's, 6 lawyer B's, 6 lawyer C's, and I gave no one lawyer D. I didn't pass it out, okay? So if I had a bigger class, there would be many of you, all right? So just to give you that kind of framework, right? So one of the lawyer A's, who is the lawyer here? You are the lawyer. Tell the rest of the group the story that your client told you. What is his trouble?
Well, my client is a representative
Tell everybody.
of a medical company which produces filters for dialysis, and he has a concern that some of the filters they shipped last month are defective and potentially can cause death of the patients. And there is one death. However, it's not sure whether it's linked to the defective filter or not. And the client, of course, doesn't want to publicize this and wants to minimize the responsibility of the company, and he doesn't even want to replace the defective filters. So that's.
How did you advise him?
There are some
questions.
Yeah.
So how do you answer some of the questions?
Whether I continue to represent him or withdraw from the representation, and there's and I can do information secret or reveal it. So first, we definitely rejected the option to withdraw from representation and the information secret, as it was no good to.
So you're going to keep him as a client?
I would prefer it.
Okay.
I think what I think there. If like I did my job right, then I would persuade the client to assume some responsibility and at least to replace the filters and eliminate the further risk of injury.
Okay.
So it wouldn't make sense to withdraw in the beginning and not to do anything about it. And definitely, if the client wouldn't take the steps needed himself, then there was a need for me to reveal the information. I would tell him, and it would be better for him to reveal it himself.
Yes. And what if he refuses? What if in the end he says, I will not replace them, the ones that are out there that may be harming people, and I will not reveal about it?
Well, then I think it's ethical, both ethical and legal obligation to reveal it.
At that moment, you would reveal it. If it came to that, you would advise him to do it himself. But if he refused, you would reveal it.
Yes.
Okay. How about the other client and lawyer A? Is it the story the same?
The story is the same.
Okay.
And I would prefer to persuade my client to deal with the situation.
Of course.
Himself.
Of course. So you tried, both of you, to use the confidential relationship you have with your client, the protection of confidentiality, to counsel your client, to persuade your client to behave in a certain way. That was your goal. Okay?
And I would present all the possibilities of the responsibility, because in the case that the filters would be defective, the clients need to know what the results would be.
Okay.
And in the case that my client would refuse to solve the situation, I think I would be obliged to deal with the situation myself.
And deal with means what?
I would need to prevent any possible future harms, because this is the exceptions of the confidentiality.
Okay. So if you were an American lawyer, you would base it on which part here?
The physical.
Oh, I moved it, didn't I? Sorry. Part 1. Okay. You would reveal it. And you the same under Part 1. Okay? Okay. Anybody have any advice for them? Do you think they answered these questions correctly? You know the story that the client gave now. You know the first choice of the lawyers, both of them. And if I had 10 client A's and lawyer A's, they would disagree with each other, I promise. So it happens that you guys agreed. Any advice for them? Do you think they've done a good job? How do you feel as clients? Are you very happy? No. You're
Well, of course not, but I know the possibilities, I know the worst that can happen to me, and I don't know the less that can happen to me, so I'm trying to balance my pros and cons.
The least that could happen to you would be that your lawyer would keep his mouth shut and no one would find out that you were killing people.
But he said he cannot do that according to the...
So he advised you, he told you truthfully that he would not keep this secret.
Yeah.
Will you change lawyers?
Well, I know that he will reveal it anyway, so
Okay.
change of lawyers is not the
So
solution.
if something like this happens to you again, will you go to a different lawyer?
Well, I would seek another advice, probably.
Okay.
Yeah.
And would you tell the lawyer all of the information?
Well, of course not, because
Of
now
course
I know.
not. Now you
It's
are
a lie.
smarter. You have been educated as a client to not tell lawyers these
Well,
kind of things, right?
To not tell the fact that he has to reveal according to the law or
Yeah. Okay, all right. So these are the relationships that change and adjust as lawyers make decisions, even if they're the right decisions. Sometimes, right, we have to recognize that clients are smart people too. They can be educated by the circumstances that happen to them, and they might go forward into new situations operating differently, right? Okay. So I agree with I would explore and get more people to comment, I hope, out in the group, right? This one is based on a real case, actually a series of real cases in the US, but it was a company lawyer, so it's important to know that it was an internal in-house lawyer, and maybe you know that in-house lawyers are treated very differently in the US and Europe with respect to confidentiality. Do you know this or no? So there's an important European Court of Justice case, Axo Nobel. It's a company case that established that a company lawyer is first an employee and only second a law-trained person, right? You happen to be a law-trained person who is an employee of a company, and you cannot maintain the same level of confidence. You cannot, for example, take advantage, if you're a company lawyer in Europe, you cannot take advantage of the law that we talked about earlier that protects you from having to go to give witness against your client. In the US, a company lawyer is first a lawyer and second an employee. So there are some changes, some differences, but for confidentiality, they have no different confidentiality duty to the client, their company, than a private external law firm lawyer would have. Okay, so it's a big difference. But in this fact pattern, it was a case that came in the state of Illinois. The lawyer told this company CEO, you need to tell people about this. You can't go on, possibly, it looks like we are killing people, right? We cannot go on doing this. I am going to reveal this to the Federal Food and Drug Administration. It's the agency that's responsible. Hello, please come in. It's the agency that's responsible for monitoring, food products, medical devices, things of that nature. This is definitely in their kind of jurisdiction. And the lawyer said, I will reveal if you don't. And the CEO said, it's been nice having you work for the company up to this point, but we really don't need your services anymore. Okay, you should find another job. And the lawyer went out and revealed. Okay, now, what rights do employees have? Anybody know some employment law? What rights do employees generally have when they are terminated or their employment is adversely affected somehow because they have reported misconduct or unlawful activity by their company?
Protection of whistleblower.
They have some protection, right? They have protection, we call it wrongful termination. It's sort of a whistleblower protection. Some of our states have statutes that are called whistleblower protection. You have that in Europe, I know you do. This lawyer, the way this case came about was this lawyer who was terminated for saying he would reveal, and revealing, in fact, he did reveal. He filed a claim against the employer saying, I should get the benefits of being an employee who's been terminated for a bad reason. It went through the state courts to the highest state court in Illinois, and the highest state court in Illinois said, well, no, you don't get that benefit as an employee, you're a lawyer. If you are a private lawyer, can a client fire you? Terminate your representation? Of course. And in fact, the law in the States is, and I think it's true in most European countries where I've looked at it, the client has 100% right to terminate a private lawyer. They don't have to have a reason, a good reason, a bad reason, any reason at all, because we want there to be sort of a trust relationship between lawyer and client, and if it breaks down, we want the client to be able to fire the lawyer, to end the relationship. The Illinois State Supreme Court said, well, you know, you guys want to be treated like lawyers even though you're company lawyers. Well, you are going to be treated like lawyers. You have no employee rights, other than if it says something, you know, if you had a contract, individual contract, but the law won't, you know, protect you separately from it. Some U.S. states have had almost exactly the same case, not involving medical devices, but otherwise the same kind of case about a lawyer who reveals confidential, harmful information about their client when their client is violating law. Company lawyers. Some of our U.S. states have said, yeah, you're a lawyer for confidentiality purposes and things like that, but we will also protect you like an employee. And we will give you both protections in effect. The Illinois court didn't do that in this particular case. So the law is actually different from state to state within the U.S. on this particular point, whether he gets protected or not. Now, if we had more time, I would expand this to a conversation about counseling clients, because that's what you guys tried to do. And so you were able to put confidentiality into action. You were able to actually do something with what you understand the law of confidentiality to be. You began to understand the limits of confidentiality, and you expressed them to your client. Maybe your client liked it or didn't, but that's what happened. You put the law into action. There are old cases about products liability situations that involved lawyers, like Ford Motor Company, for example. This goes back a long way. But Ford Motor Company had made a car with a badly designed pipe connecting its fuel tank to the filling part, right? The filling outlet so that you could put the fuel in. They had made a badly designed pipe, and when one of these particular kind of Ford cars was struck in an accident near that place, it would blow up. Ford did, with the help of its lawyers, did a very long, very tedious study of how much it would cost Ford to pay damages to the number of people it could predict would be killed by its cars versus how much it would cost to bring in those millions of cars and replace the pipe with a better pipe. And they decided to pay the damages to people they were killing. I mean, they made this decision in paper. Sort of like your client might be trying to decide, you know, maybe they'll catch me, maybe they won't, but I'm killing people, it might cost me money, you know, but I'm not going to replace these filters because that's too expensive. It was sort of the same kind of economic study that was done. Do you think this turned out in the end to be a good decision by Ford? No, not so much. It wound up, you know, costing them horrible, and we have, of course, punitive damages. So, you know, at the point at which juries began to learn that Ford made an economic decision about how many people it was willing to kill, you know, punitive damage awards began to go like crazy against Ford Motor Company when they did kill such a person. It was not a good thing in the end for Ford. All right, so I would expand it. We would talk about lots of those kind of things and lawyers' involvement in client wrongdoing and all sorts of stuff, but you get the idea. Where's a client B and a lawyer B? Okay. And can the lawyer B tell us the client's story?
Okay. My client is charged with murder and
a murder.
Murder and robbery of one tourist, and he is now in detention. He sent me some information that there can be one of evidence which can be in which can be not in his interest. Yeah, it's a wallet.
It's a wallet.
Right, from he take the money of within, and he say me that this wallet is in a trash container.
Trash container.
Yeah, in front of his house, and
client's house.
Yeah.
Not victim's house. Client's
client's
house.
house.
Would be bad for him to be found there.
Yeah, there is possibility that the police officer can find it, and he tried to say me that he can't take it from this container, and I should do that. So it's a difficult question, and I decided to say him that I keep this information in silence because it's my right, and this evidence is not in his interest. And I think that my duty is to give him my best services, and it's not in his interest to show this evidence to the court.
Okay.
It's not my duty, I think. And
but so first you will not tell the police or the prosecutor about this. Okay.
And after that I say him that I can't do this for him because I have some responsibility, ethic and legal responsibility for my behavior. So I keep silence. And
you'll keep silent, but you won't go and take the wallet from its place.
And say him that it's not a good idea to do that.
Okay.
By another person.
And the other lawyer B, what did you decide? What have you? Is the story the same?
Yeah, probably the same. I would say that it's my obligation to keep it in secret, this information about the wallet.
Okay.
Because we can't prevent any serious harm to these interests. So it was in the past. So there is no prevention. Obligation. I would say that if I or someone else with my order will go and pick up the wallet, we will commit a crime. And I am not obliged, and I have to refuse instructions from my client which tends or instructions to me to commit a crime. Because it's a crime to break the evidence or
destroy the evidence,
destroy the evidence and so I'm here. My role is to help him. But my role is interest of the client, but my role is the same. Is to help the system of criminal justice in this will work. So.
Okay. Now, would it help you? Anybody else think, if the lawyers do or don't think this? Would it help you as a lawyer to know the condition of the wallet and whether it is still where it was placed by your client? Did your client tell you anything about the condition?
He said only the place and
only the place, nothing else?
Fire.
And it was burned. But he does not know how much burned it is. Would it help you prepare the defense of your client if you knew that the wallet was totally burned, would never be found, or if it was already gone from that place, you might think it was already picked up by some trash collection and was gone, and therefore would never be found by police, right? Would it help you prepare your strategy to know this?
Yeah, I think that is a difficult question because I have not obligation to. So I can't destroy this evidence.
You can't destroy it.
But I can research for evidence. It's a difficult question.
You are allowed to investigate, aren't you?
It's a difficult question.
And it's the confidential relationship with your client that has allowed you to learn this information and has allowed you to make the decision, both of you, that you're not planning to reveal this to anyone.
So you mean to go there and to see the...
I'm asking, is it a good idea or a bad idea?
Container?
Yeah, do you want to do it or not?
If it's still full or I think I can do it.
You can do that?
Yeah.
Okay, does anyone think that the lawyer shouldn't do that?
I think it's about interpretation, but I think that it's my colleague that You
should go and do it.
Yeah, but only see it.
Only see
it or something like that.
Okay, what if you would, maybe you go and here it is. Okay, here's the wallet. And the trash is over here, yeah?
Okay.
And you go and you look.
No.
No? You won't touch it?
No.
Maybe with a glove. Can you touch it with a glove? What would you destroy if you just touch?
Oh, I said this is a difficult question. I know that there is balance between crime
you just want to look and see.
Yeah.
Okay. Would you like to know if the identification card of the victim is burned or not burned? Now you can see the wallet is not completely burned already, but maybe the identification card is burned. Is this information valuable to you to help your client?
Yeah, it's valuable, but I must say that I think that I don't go there and do something with this wallet, but
you won't even do it.
No.
Will you do it?
I will go and see, but not touch it.
You won't touch it in any way.
No.
Even with a glove.
So I would be afraid that I can still destroy some evidence because I don't know the expert.
Will anyone even pick it up and look at it? Even with careful gloves. Anyone. Pick it up and look. Anyone. No one. Or you just don't want to defend the choice. You would do it, but you don't want to defend the choice.
I'm not quite sure about the criminal procedure in
Yeah.
USA, but is there a discovery as well? So once I have an evidence, I have to show it to the other party?
That's a good question.
And that's what I would tell my client. I would go there, I would pick it up, but
put it right back.
And not right back. I would have to show the other party.
Well, even if you look at it, you think you might have to show.
Well, if I look at it, I
look,
show, of course, but
and I walk away slowly, like this one.
I'm not like that.
No, you don't walk like that. Okay. Okay. No one else wants to look at it. Okay. I will tell you that the law of criminal procedure in the U.S. is that an item, a thing that comes into the full possession, really full possession of a lawyer is not privileged, cannot be kept by the lawyer, right? Otherwise, what would happen? I mean, it has happened in certain cases, and the lawyers have gotten in a lot of trouble for it.
We would cover the fact that the criminal acts.
Yeah, the client would bring the stolen money to you. The client would bring the gun that he used to kill someone to you, and you would keep it in a box somewhere hidden. That can't make sense, right? It's information. That's what is meant to be protected as confidential. It's the communication from the client, not things they give you, right? It only makes sense. So things are not subject to this kind of confidential protection. What kind of thing do you think creates controversy sometimes about whether it's a thing or not? Yeah, if a client gives me a document, they give me a document, piece of paper. The question becomes, is it a thing or is it a communication? And courts have had to wrestle with this question in the U.S. And the answer is that if it is a document the client created to communicate to you, then it's a communication, it's protected. But if it is a document that they created for a business purpose or some other purpose and they just hand it to you, it is a thing, right? It is still a thing. So their accounting books, you can't hide their accounting books for them, right? That's not, even though it's a lot of paper, only if it's a communication a document they made for the purpose of communicating with their lawyer, then it's protected, okay? All right, so you're all on a good track. What the lawyer actually did in the real case, there's a real case like this. The lawyer went to the trash, found that it's not that burned, took it away, back to the office. At that point, even if the lawyer has done nothing to like wipe off the fingerprints or throw something away, has the lawyer destroyed some evidence?
Yeah.
Yes.
Yeah.
What has the lawyer destroyed? The context, the location of it, right? This is evidence too, because it was to be found in front of the client's home, the defendant's home. This is a very important piece of information, right? The court wound up saying the wallet is not privileged. It's a thing. And indeed, the lawyer in the real case, after he got it back to his office, I think realized this was a bad idea. It was fine to look at it. It was fine to look at it as long as there was nothing ruined or destroyed, covered up. You wouldn't, pile other items on it. As long as it was left as it was and not changed in any way, it was proper to be allowed to investigate it a bit. Yeah, if you did it safely, and look, I don't like that, but then you put it back how you found it, and you do that walking away slowly like I did, right? It would all be fine. You would not have truly possessed the wallet, so you would have had no obligation to give the wallet. Once he got it back to his office, he had to send it in to the authorities. He had to send the wallet in. But even sending the wallet in, you all recognized he has destroyed some evidence, the location of it, the context of it. And the court said the protection of witnessing against your client does not apply when you destroy evidence. Yes, it applies to what your client told you, and if all you did was that very minimal kind of investigating, looking, when the client has told you, you would never have to reveal anything. We know he'd have to give the wallet if he takes it away, and the court wound up saying, I think correctly like you guys noticed, he has now destroyed some evidence. We are going to force the lawyer to tell the court where he found it. That piece of information that he has destroyed every bit as much as if he had wiped fingerprints off of the item. So it's a way of understanding how big or how limited is the subject matter, the protection, the arena where there is protection of the confidentiality. It doesn't protect things. It's a good story to teach that it doesn't protect things. And it's a good story to teach that it falls apart as protection if you destroy. Right, if you destroy. Okay? So we would expand it to some other examples if we had enough time to do it. So I've already gone kind of way over. We might as well talk about case C.
So I'm the lawyer.
Yeah.
You see, I have this new client.
Yeah.
He's accused of murder. And
he's also accused of murder.
Yeah.
We have a lot of murderers today.
Yeah. And after some time, I'm talking with him, and after some time of this lawyer-client talk, he suddenly revealed that he committed some other murder years ago. So for some, I don't know the reason why he told me, but for some reason, for some bizarre reason, he did it, and
bizarre reason he told you.
Yeah.
Okay.
So now I know that he has committed some murder. Some, I don't know how many years ago, a few years ago.
A few years. Okay.
Yeah. And now he is accused because of some other murder. It's
and the new murder he committed or not?
He says he didn't this, but well, I trust him.
He didn't do the one he's charged with?
Yeah.
But he did another one in the past?
Years ago.
Okay.
So, yeah, it's a hard question, but
well, let me stop.
Yeah.
First, it's an easy question, right? You don't plan to tell people about your client's past
No,
acts.
It's not possible to prevent some someone's death, or so it's a past thing.
Okay. What makes it a hard question then?
The question if I should withdraw or not.
Ah. Okay, so there's no other piece of information?
I'm not sure.
What happened as a result of the prior murder? Were you ever charged with the old one?
No.
No, what happened?
Never accused of the first murder.
Okay. What happened? Was it ever solved? Did they capture someone? Did the authorities charge someone else?
We don't have this information.
We don't have this information.
Okay, I believe you do, but that's okay. So for
it's there, I know.
Yeah, so for the sake of moving along with our short time, someone else was charged with that murder, an innocent person, because you did the crime, the old one. This other person who is completely innocent was mistakenly charged and is still in the prison. He is in the prison for a long term. He has been convicted falsely of a crime you committed. Okay? Does that make it any harder a question than just saying I wouldn't reveal anything about my client's past crime?
Sure.
Sure. How does it make it harder?
Because there is some other person's life at stake. It's in question. So some person who did not commit it.
Yeah. So there was some great injustice and someone suffering every day.
Yeah.
In the prison.
So it's the situation is maybe quite similar as this prevention case, because I can prevent his lifetime prison.
Yeah. You could, by revealing that your client committed this crime. You could start his suffering.
Yeah. So
instead of this other person who's innocent.
Yeah. So this is this way this possibility is quite hard, but I'm his lawyer, so I'm a special person who is in a special relation.
So do you think you will tell the authorities about their mistake and that it was your client instead, or not?
I would very probably withdraw the case as a lawyer.
Okay.
Because in this point, I'm not sure what I would do, but I should probably keep this information in secret.
You will probably keep it secret, okay?
But
how many people think they would keep it secret under this situation? How many people think they would reveal it? Okay, some of you just don't want to say one way or the other, but so some of you would reveal. And would you have, it's not up there anymore, but would you regard it as preventing future substantial bodily harm to the person who's in prison? Is that why? Is that how you would justify it in the ethics rules?
It's not bodily, but it's psychological.
Yeah. It's hard to tell. How many of you have ever been in a prison? Well, I mean to visit. I know that most of you, I assume you have not been. Anybody?
Yeah.
Yeah? Okay. Yeah, my first work as a lawyer was representing prisoners. So I was in prison, maybe 3 days a week, off and on, to visit clients. Some people argue that it is physical bodily harm to be in a prison for a long time, at least, maybe not 2 nights. but for a long time, that it is substantial bodily harm. Other people will say, absolutely not. All right, absolutely not. It's maybe...
Now I have a client who was in detention, and he said, if I will go back, I will commit suicide. Just because of the first sentence or first detention, so it's really hard for them. So it's not the same, but similar. So maybe
okay. So those of you who said you would reveal, why would you reveal? Why would you tell? Whether you think it fits that exception or not, I think some of you would reveal even if you don't think you would be complying with the rules of ethics.
Well, as the lawyers previously in the research said, I think that's the right thing to do. So.
Ah, right, okay. Yeah, it's the right thing to do, that's enough.
I probably couldn't be a criminal attorney. I would be state attorney.
Okay, okay.
So, even in the previous case, I would consider...
You just sort of wouldn't be able to live with yourself. If you had kept this secret and knew this person was wrongly in the prison every day of your life. When you woke up in the morning, that would be too hard for you.
Yes, I believe the attorney role should be like finding the the good side of trying to improve the client's situation, but not to lie, which is, I know.
Yeah, and here there would be no lie taking place. No one would ever ask him about this crime. They've solved that crime. There's a man in prison. No one is ever going to ask him about it.
Well,
right? So he won't have to lie. He will just have to keep silent about a very important piece of information. Yeah, it's hard to know. How about either of you? Do you have any?
I think that it's kind of prevention, like saving the life of that innocent person, because the quality of life is like minimum more, so it's the same as if he was dead.
Okay, okay.
If it's a life sentence, for example.
Yeah, and it might be made easier for you if you lived in a place that has capital punishment, and this person was, 6 weeks away from being executed for the crime that your client committed, not this guy. Then you might feel even more strongly about revealing it. Some people would, right? I think. So this is an example for me, and I talk about it with the students, where the rules are not very good. The rules are not perfect. At least they don't match up with the way many human beings would interact with this kind of information, or would want to interact with this kind of information inside. And I tell them some stories. I won't keep you here, we're almost to lunchtime, but I tell them a couple of stories about lawyers who have made a conscious decision to break the lawyer ethics rules because they couldn't be a human being anymore if they followed them. And they do it, the ones I would tell them a story about, do it in a sort of honorable way. They recognize that they will have to take the consequences as a lawyer. They may have to be punished as a lawyer for doing it, but they just can't, kind of manage life otherwise. So I know some people who have had that choice to make. I would also tell them, I'll tell you just really briefly, about 2 cases just like this one that happened. And in both cases, they're the same in some way and they're different in ways. In both cases, the lawyers kept silent until after their client had died. And in both cases, it was more than 20 years that they stayed silent and waited until after their client died and then revealed the information. The man in prison was still in prison. He had been there all that time. In one case, the lawyer actually, it was 2 lawyers working together, actually said to the client who revealed this information, "We would like to reveal it. We believe our ethics rules won't let us. Would you sign a document that gives us permission to reveal it after you die?" They asked him if he would do that, and he did it. The client signed a document that said, "I give my lawyers permission to reveal this information after I'm dead." And they waited until he died, and then they revealed it. they were the subject of investigative journalism that was a very broad criticism of lawyers. Because here they were saying, we followed our ethics rules and we kept quiet all these years because that's what they said, our ethics rules required of us. So we were being good lawyers and bad human beings. But we were being good lawyers. And that's what we needed to do.
I think this is exactly the problem of this term legal ethics, because well, the better is probably to speak about some rules of conduct.
Yeah, exactly.
Because from the ethical point of view, it's probably a completely different situation. Like,
yes. I agree with you. And so, although we call it lawyer ethics, and I often fall into the trap of saying that, I try when I'm outside the U.S. to say lawyer conduct code or law governing lawyers, because that's what it is, as opposed to a philosophy course, right? It's not about philosophy. Although there is a quite legitimate way of thinking about it as a philosophical matter, that we often call role morality, right? That the morality of certain individuals who are meant to play a certain role in an organized, civilized society may be contradictory to ordinary morality. So while the ordinary person, not in our example now, but make it an even more straightforward, simple one, if a person came to me, and I'm not a lawyer, and they tell me they committed a crime, my moral stance ought to be to help you get punished. Right? That ought to be my ordinary morality in that situation. But we absolutely do not expect the criminal defense lawyer to think that way. And they're not supposed to think that way.
I think it doesn't have to be ethical question, it's a legal question.
Exactly.
You said that the ethic code is a law.
It is.
So my client should know that if he tell me that information, I will have to tell it to police. So it's his responsible. He told me.
As
so
an ethics matter, as a philosopher.
I think it's my. I meant that his duty, my client's duty, is to know the law. And he should know that my duty is
to follow.
To tell it.
Yeah.
So it's when he told me that information, he should know that I will tell it to police. And at the moment he told me, he gave me permission to tell it.
Yeah. So what the client actually does know in that situation is that criminal defense lawyers do not tell. They do not tell unless they are preventing future substantial bodily harm and so forth. So they, generally speaking, the law prohibits them from telling.
No, there's a guy in prison, and he suffer harm from being in prison.
So I agree with you. I actually wrote an article arguing that, but it's not the majority position. The majority, unquestionably, is that the criminal defense lawyer does not tell. In the second case, where they didn't ask permission about after death, they waited till after their client died, but they had no permission from the client to tell. They waited till after he died, they revealed the information, and the Bar Association immediately charged them with disciplinary violation for revealing their client's confidential information. So it is important to know, and it's true, that the duty of confidentiality, the protection of this information, it does in fact last after our clients have died. It does. It lasts forever. And if we had time, I would tell you a difference between government lawyers and private lawyers in the US with respect to this time limitation. But as a general rule, it lasts forever. So you were going to say?
I just would like to add some idea of possible solution. We have this role of a criminal lawyer, which is quite well ordered through some statutes or some codes.
Right.
And then we have this another role, which is more, which is above, let's say above, a role of a lawyer in general. And I think that I would behave as a criminal lawyer according to these codes.
Yeah.
But then I have to think quite intensively in my mind if there is not some special idea of a lawyer as a person devoted to the law in general or to the justice. And then I would probably say that as a criminal lawyer I have to do this, but as a lawyer in general, as a person devoted to justice, I have to do something different. But
I understand.
It depends on.
So for what it's worth, and I've only spoken with a small number of Czech criminal defense lawyers. I've spoken with a lot of American criminal defense lawyers and criminal defense lawyers in other parts of the world, quite a lot. They don't think of it that way. Frankly, they regard their role as the protection of this client to the extent the law permits them to protect this client. And so they will not reveal unless some law tells them, or an ethic, or a conduct code, if they regard as law, requires them to reveal it. They won't do it. So they see themselves as honorably balancing the power of the state on behalf of this individual. And if that means that they need to push their role to the furthest limit that the law allows to protect this person who is their client, they will do it, and they regard it as that. They don't believe that their role is to find justice if justice is bad for their client.
Well, not to find, but to
facilitate or make it happen.
It's balancing of interests and this.
In general.
In general, it means that we, as a criminal lawyers, think we have only one position and one obligation. So there is no balance, and it's a really very hard situation. I've never met this situation in my 8 years of criminal. So.
Yeah, but your mentality is not to primarily look for a just result. No, your primary goal is to look for the best lawful result for your client. Yeah.
I believe completely in this, but I think there are special situations in which we have to balance and weigh this.
And this may be one of them. Yeah. So there were these two actual real cases, and the lawyers involved in them were on television, held up for public criticism by the media to say, this is what lawyers' rules tell them they have to do. They have to let that guy stay in prison for 20 years. And that's what they did. And on the television, the lawyers involved told a story of how painful it was to them as people. That they, their lives were not the same as they had been before they learned this information. Their lives were not as rich. They didn't feel good about relationships they had with their family, that there were all sorts of difficulties that they suffered as professionals. Of course, not the same difficulty as the guy who was in prison, right? But it was hard. I think it was actually a hard thing for them to do what they believed the lawyer's proper thing to do was, the criminal defense lawyer's proper thing to do was.
Wasn't there any discussion about changing the rules afterwards?
So there are two states, Alaska and Massachusetts, who have added one more exception to this list of 6. And it says that a lawyer is permitted to reveal client confidential information to rectify the consequences of a wrongful conviction of another. Right, which in this situation would permit those lawyers to do the revealing. So there are 2 states that made that decision. And as I said, I wrote an article arguing that that should be the rule, that you would be permitted to reveal in this situation. But definitely it's not. I got hate mail from criminal defense lawyers, when I wrote that. Not that I'm not really afraid they're going to hurt me or anything, but they didn't like it at all.
And it's just permission to do that. They don't.
Yeah. So the ABA and most states, but not all, use the word may. They use the word may, these ABA and the states, they use the word may because they do not want the lawyer to have liability for failing to do it. They want to permit it to be done, but don't want, for example, to create private liability on the part of the guy in prison, right, to sue the lawyers when it comes about, to create a private right of tort action of some kind, right? That's why they say the word may instead of must. Maybe there are 10 states that have substituted the word must in that rule for all of them, for all of the list, and a few states that have must for some and may for others. So when we teach about the ABA model rules, which is what we teach about in the courses, everyone understands that the individual states have changed them to some extent, right? They have, they all 50 have something close to the model, but they have made their own individualized changes to them here and there. Okay, I should never keep students past lunch. So we'll come back. I will do a confidentiality class, and then we'll spend a little bit of time just having a conversation about why use these methods, how do they work, what happened in the classes, how you kind of reacted to the different ways in which I was trying to get you involved. Okay? All right, so we'll see you at, I guess we should make it 1:10, since it's already 10 after 12.